to talk about Florida State. In fact, here's one of them right now.
There it
Doug,
is.
how you doing?
I'm doing all right tonight. Give me just a minute to fix my audio. Let me make
Okay,
sure I
you
got my
tell us when you're
computer.
ready, and we'll dive right in. I'm just going to get us started by saying thanks for everybody being here tonight. It's going to be a fast and furious however long we're on because there's so much going on in the news, and we'll try to catch everybody up on as much as we can. The longer you guys have questions, the more we'll be able to answer them for you. So please buckle up, follow us all on Twitter, subscribe to us on YouTube, and then turn on your notifications so you know when the next show is going to be on. So I'm just going to dive right in. So I know we have you for a little bit of time. Doug, you take off. I know families first. You leave whenever you need to. Jen's going to be
There
joining
we
us
go.
here in a second, but just want to catch everybody up as to where we are today. And then I've got a bunch of articles that I pulled that we can sort of parse through if we have time. So kind of catch everybody up where we are with Florida State and the ACC.
Sure. Well, thanks again for having me on. It's a real pleasure to share this information. As a Florida State fan and attorney, I like to jump in and dive in and just digest this information for myself. And I love explaining it. I love making sure that it's in a clearly intelligible format for all of your viewers as well. The reason why we're in the news again today is because the ACC and North Carolina has filed what's called an amended complaint. Amended complaints are very typical in litigation. It's not an unusual process at all. You'll recall if you watched the last video or followed what was going on, the ACC actually filed their lawsuit first in North Carolina before FSU filed their lawsuit the following day in Florida. So now the ACC, having Florida State's lawsuit, could glean some of that information, and they're supplementing their original complaint to come up with their new and expanded reasons as to why FSU should be penalized, and more importantly, to stop FSU from doing certain things during the litigation. So that's the real big issue that's coming up. ACC is asking a judge to determine, regardless of what the outcome of the trial is, don't let FSU be an active member. They have to sit on the sidelines while the ACC moves forward with all of their business. We also want FSU to stop sharing information. A real contrast between the two lawsuits that were filed. The ACC filed several of their exhibits, what's called under seal. So they filed them with the court, but they asked the judge to keep them private, not make it part of a public record. Whereas Florida State, they filed their lawsuit, threw all the papers up in the air and said, have fun with this. So they're trying to make sure that the FSU and their board of trustees doesn't disclose some of that privileged and private information that's involved in the ACC and ESPN contracts.
So this first tweet I saw, and there's a pair of them, but this first tweet that I saw go out, I'm just going to read it real quick. It says, "This part actually gets me excited. It will increase the urgency of the case because the court will not want to subjugate a member to that organization for an extended amount of time, extended period of time, without any input to the management." And then in the second part of that, you said, "This also discourages other members from following suit in these claims, seeming a very defensive position to take when you know how you have a losing argument."
Yeah, so that's what I'm positioning this as a response and saying. I think that this filing really shows the weakness of the ACC's position. So the first thing that they're arguing is not only is this a valid contract, but you specifically stated in your contract that you wouldn't challenge the grant of rights. You've now done that. So that in and of itself is an active breach of the contract. Everything else, the declaratory judgment action, you will remember, you're trying to get a judge to decide what happens if we breach the contract. Is the grant of rights valid? The ACC is now arguing because you even filed this challenge, now you're in breach. But what the other part of this is the ACC trying desperately to discourage any other members from following suit and filing. So they're trying to penalize Florida State on the front end and telling Clemson, telling Virginia, telling Miami that, look, if you're thinking about doing this too, we're going to smack you pretty hard, set you to the side, and not let you discuss any ACC business while this litigation is pending.
Has that ever happened before? Are we dealing with new law?
No, well, yes and no. So you asked two different questions in the same sentence.
Oh,
We're
sorry, I wasn't trying
dealing.
to trick you.
No, it's not. You may not have even realized it.
Yeah.
The grant of rights challenge in and of itself, and I mentioned this in another tweet, that is a relatively novel area of practice, novel area of contract law, because there haven't been a lot of grant of rights that have been taken to court and litigated. So there was some successful defense of the grant of rights with Texas and Oklahoma leaving, but that was only 2 years remaining on their grant of rights at a much lower dollar figure than what Florida State is discussing. Now, the other part of your question was, and I don't even remember at this point, but you were asking about, is this new? What was the second part of that?
I don't know. I forgot myself. Do you guys recall what I said? I always ask for help from the peanut gallery if I can get it. Don't worry about it. The second part probably
Sure
wasn't that important. That's what my mom always told
You
me.
were talking about if this was the first time that we'd ever.
Oh yeah, right. Is
Yeah.
that the first time
So
we've ever seen this?
it is the first time we're seeing this type of litigation, but their clause, their argument that, look, you signed it, you're bound by this agreement not to litigate. That's something that just a public policy is not going to support.
All right, very good. I want to add Jen to the conversation. Jen, I know that you've been having these conversations with both Doug and with Danielle. You've been beating the weeds for the last week on this, and in this lull of the news. Is there anything that came out today that surprised you from what you'd been hearing, Jen?
No, nothing. Well, okay, I'm going to take that back a little bit. I'm a little surprised they put in there in the amendment to take away the voting rights. I think that's a wild thing to do, but I also think it kind of showed the ACC's hand a little bit. I think it showed their hand a little bit. And I say that because, one, they allow Notre Dame all these votes. Notre Dame gets to decide who gets to be invited to the ACC, right? They get these votes when they bring absolutely nothing to the table because they're only in on sports that, you know, for better or worse, don't exactly move the needle in the money wise department, right?
Right.
So yeah, the ACC is totally cool having somebody with a vote and allows them to throw their weight around with inviting Cal and Stanford, that absolutely has shown to not bring any monetary value to the ACC. And now they want to file a lawsuit saying Florida State should lose their voting rights. Well, Notre Dame just gets to continue.
Right.
It's weird to me. I think so. Again, I think they kind of showed their hand here. I think this was this is a strong arm move. I think they're trying to strong arm them. And Doug, you can chime in. I'm not an attorney, but this is a settlement. This is a settlement move. This is a settlement move.
You're trying to drive people to the settlement table is what you're doing.
Yep.
Okay.
Yeah.
And
And
that
in
went
what
to
way
the
is
second
that
part of
the
your
case?
question.
Oh, okay.
That was what you were asking, was, has this been done before? And yeah, that is what happened with Texas and Oklahoma. They were temporarily stripped of their voting rights while that litigation was proceeding. So a precedent has been set for that to happen. It's not, what it's going to do is it's going to increase the urgency, to my post on Twitter. It's going to increase the urgency on the part of the judge, who's not going to want to be sitting back and making Florida State sit there as a silent partner. It's going to encourage them to expedite the litigation process.
Yeah.
If I could on that part real quick,
Yeah, go ahead.
would you say this bears any resemblance at all to what happened up in the state of Washington in terms of how Washington State and Oregon State were given some similar power over the PAC and the others had their rights removed? Or would you say legally it's a different situation, even if it seems similar?
I think, again, that goes to it being two separate issues, the grant of rights, and that's going to be litigated as a separate issue. But again, to that point, the PAC-2 then were the only parties that had authority to govern the conference as it was moving through this following period. So bringing on other members, voting to include other members, those who were leaving the Pac-12 were disallowed to have their vote and their say And that's exactly what the ACC is asking for. And frankly, it's probably one of the few winning points that the ACC has during this process.
Yep.
All right. Let's get to a few of these line items. This is a tweet. Let me back up. This is a tweet by Pete Thamel. I don't want to strip away his credit for putting this brief description together. Really quick, I'll just read these really quick. First claim for relief, request for declaratory judgment. That one is they just tell us, just rule right now and throw it out, right? Isn't that what that means?
That's restating what the original complaint was. That's just saying, don't forget, this is the original issue in controversy.
Okay, and then the second claim for relief, Florida State is stopped, I guess, as legalese by its acceptance of benefits or has waived its by its conduct any challenge to the grant of rights. Is that the same thing stated a different way?
No, this is a very interesting thing, and estoppel is your word of the day. That's your SAT word that you're going to learn from this filing today. So estoppel is saying you're not allowed to do something. So in contract, there is a theory, there is a situation where if I pay you $1 million to do X, you can't take that $1 million and then refuse to do X. You're stopped from breaching the contract because you've taken the $1 million. Well, in this case, the grant of rights is prospective. All of this litigation is about what happens between now and 2036. So the fact that FSU got money in the past, I don't think is an accurate use of the principle of estoppel to say you're not allowed to challenge this going forward.
Okay. Third claim, Florida State has breached its promises in the grant of rights. What is that?
So this goes back to what we talked about in the last conversation. There was a provision in the contract that says you will not challenge the grant of rights. This is a very weak argument in any contract situation because contracts can be broken under certain circumstances. And so what they're saying is, look, if you are abusive, if you are baseless in your challenge, we're going to come after you for attorney's fees. So you shouldn't have brought this litigation to begin with. We told you if you brought this litigation, we were going to penalize you. Now that you brought foolish litigation, I'm not going to feel bad about hitting you up for attorney's fees. But again, in this case, the Florida State argument is much stronger than I originally thought. And so I don't think it's baseless or frivolous.
And do you think that this piece would be, if they do lose, that they would the ACC did win their argument, then they could come back and then they could sue for the attorney's fees or anything else as a penalty? Is that the third claim?
Correct.
Is that kind of what they're going for?
That's exactly right.
Okay. Fourth claim, Florida State has breached its obligation to protect confidential information. Now, this I found interesting because obviously what was revealed is the grant of rights was actually revealed to the world, even though it wasn't ever owned, that Florida State is the one that revealed it. They said they found it on the internet. But there has been other stuff, tradecraft, that's been exposed for this legal dispute. This one I found really interesting. I thought anything you file would be public domain. Is it not?
So that's the interesting comparison between these two lawsuits, and you can see how the parties behaved. When the ACC filed its complaint in North Carolina, several of their exhibits were submitted what's called under seal. So they've turned those documents over to the court, but they're asking the judge to say, this is sensitive information. We don't want it to be part of the public record. Whereas Florida State, they just threw everything out there. And yes, one of the important disclosures that were made in the Florida State filing is this idea that ESPN has a unilateral right to extend in 2025 their rights from 2027 to 2036. So that's an example of where the ACC is coming back and saying, whoa, 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 FSU needs to be punished because they were disclosing things and they need to be ordered not to continue disclosing things, especially as we get into the discovery phase.
And what would that be? What would the punishment potentially be?
There's a whole bunch of things that a judge could do. The worst thing that could ever happen is for a judge to strike an answer. What that means is everything that you say in your answer is null, is invalidated, and now we're just going to proceed on damages. The plaintiff wins because you don't even get to reject the plaintiff's claims. That's not the type of violation that this would be, but it could come with an admonishment. You never want to piss off a judge who's hearing your case. So the judge might say, that might not have been the smartest thing to file. Going forward, let's make sure all the filings go through my office and I can make a determination as to what should be public and what shouldn't be.
Okay. The fifth claim, Florida State has breached and continues to breach its fiduciary obligations. Let's see, make sure I read the rest of this. To the conference under the ACC Constitution and bylaws and North Carolina law. This one I found extraordinary because basically it's saying we want to hold you liable against the laws or bylaws of a conference. What does that even mean?
Well, some of that language is artful and correct. Obviously, as a member of the ACC, there are bylaws and there is a constitution that outlines what the responsibilities are of the parties. But the use of the term fiduciary in there almost made me laugh out loud as I was reading it, because
Okay.
what we're talking about here is the ACC breaching its fiduciary responsibility to Florida State. They took all of the rights in, all the media rights in, and they said, let us negotiate these contracts on your behalf. That's the ACC's fiduciary duty to the Florida State. I have no clue what kind of fiduciary duty Florida State might owe to the ACC. The reality is that there are certain obligations, and maybe there's some language in the complaint about some things that FSU promised to keep secret, but that's one thing. We don't have the full filing. I believe it's about 150 pages again. I tried to go to the Mecklenburg Courthouse clerk's office and download the PDF. It's not available yet. They just filed this at 4:15 this afternoon, and it takes a while for the clerk to scan that in. So the full document should be available sometime tomorrow. But I'm very curious to see what allegation exists that FSU owed any fiduciary duty to the ACC.
So just to follow up on that, the original argument from Florida State's lawsuit was 38 pages. How much is in total is the ACC's counter?
Well, the original filing from the ACC was 181 pages.
Oh my
This
goodness.
filing, I don't know. I've seen somewhere that there was a page count up at around 150. So yeah, they're
Wow.
definitely paying their attorneys by the hour a hefty sum for this litigation.
That is remarkable. Okay, and then one last one. We'll get to this last one, and then we can get to some questions. The sixth claim of relief, Florida State has breached its obligation of good faith and fair dealing under the ACC Constitution and bylaws.
Yeah, and anytime that there are parties that come together under a contract, there is this concept of good faith. You do have to behave. You do have to make sure that you're operating generally in the best interests of the other members and of the institution, of the conference. But in this case, Florida State has been banging this drum for well over a year. So they've made efforts to try to have these conversations in private, to try to resolve these issues in a conference room. But it's the ACC's refusal to make the concessions that Florida State has asked for that has now caused this to spill over into the public domain.
Jen or the panel, anybody else have questions for Doug?
Just real quick, if I could, just to add a little context for viewers from Doug here. When we're talking about the number of pages on a filing, how often would you say you see something with a lot of pages like that, and yet there's a whole lot of repeats of the same pages on there,
Right.
or some of the pages may have very little information on them? So sometimes these numbers, they can be very misleading in terms of how much content is actually there, would you say?
Yeah, when the lawsuit first was filed, the original competing filings, of course, there was a lot of news interest, and I wanted to get up to speed quickly. So I had girded myself for a 2-hour deep dive into this long document, and then it turned out that the real brief, the written portion of the complaint from the ACC was only about 35 pages. Everything else was just exhibits. And yes, in those exhibits, a lot of times they're duplicative. A lot of times there is some additional information. So no, these are not novels and word salads. And again, the judges don't like going through that. The legal practice has shifted towards being efficient and concise. And the more you say, the less you have to say.
Gotcha.
And my dad always told me it's better to use less words than more if you have the chance. Is it the same way in legalese?
Absolutely. Again, these judges have many cases that they're ruling on. They have many cases that they're reviewing. You don't want a judge to start thinking that you are not being efficient with the use of your words and your time.
Absolutely. Jen, do you have a question? If not, I've got one more thing I was going to run by Doug.
No, I don't. Not at this time. I think he has answered anything that I've got. so
The
far.
guy, he does come in and gives us answers direct. That's just nice.
Absolutely.
So one last thing, Doug, and then we'll let you go. We really appreciate, again, I just want to tell you, we really appreciate you coming on tonight. It was short notice, and everything you've done for us, I don't take it for granted. This last piece is a post from Danielle Kelly, who we all know, who's also a fabulous lawyer. This summary of claims piece that came out of the second filing, some of the things in here I found interesting. For instance, the statement of the grant of rights and the home game coverage for the media rights, which is what the grant of rights controls, is through 2036. So they're still claiming, even though they don't have a contract with ESPN, they're still claiming that their media rights go through 2036, which one, now I thought that was interesting. And then two, it says the media rights, let's see, I jumped my head here. Let's see, media rights in the conference, the members realized more value from those collective media rights than if they had each attempted to market them separately. What I want to put in a big highlighter in that one sentence is that right now we all know that Florida State has been what, 31% of the total media value of the ESPN contract up to now, and Clemson is another 18 to 23. How can they claim this, saying it's an equal part when we all know it's not?
I think that's an excellent point. And first off, I'm a big fan of DK's. We do go back and forth on these and talk about it. She has some great insight on a lot of this information. At the end of the day, you are 100% correct. There is a disproportional value that each member institution brings. And so that is what has to be evaluated. I think one of the reasons why the ACC needs to settle this is because they're going to be embarrassed once the experts come in and start testifying about what the real true value of these contracts should be. This goes back to what we talked about last time. The original deal that was negotiated was already at a bargain basement discount because the ACC and their president at the time, John Swofford, was trying to support Raycom and the secondary market for the ACC games that was run by his son. So you have a situation where they already were working from a very weak contract position, and then they put this long-term 20-year contract together with only a 4.5% escalation annually.
Right.
Well, the SEC just negotiated a $3 billion deal with ESPN. Now, I'm not saying the ACC is on par with SEC. It's a more valuable conference to be sure, but 30 or 40 million a year versus $3 billion for their contract. I mean, it's very clear that the ACC is undervaluing their product. And so to be put up there with projections, analysts, let's look at Notre Dame. Notre Dame is not a TV member for football purposes. Again, Notre Dame is a very strong brand, but Florida State, with its history and with its marquee nature, can be 80%, 90% of the value of Notre Dame. So let's look at what Notre Dame is negotiating on their own and compare it to how Florida State's being penalized through this contract.
Immaculate put up his hand, said he had one quick follow-up. Do you have time for one more?
Yes, of course. Go ahead.
Okay, go ahead.
Excellent. I found this a little strange because this is an amended complaint. So I'm trying to figure out what prompted this. Do you think that this might have been the judge asking them to amend the initial complaint? Is this their attempt to try this in the public court? Because we don't even have a date for this in that court, do we? I mean, it's just...
All great questions. There's several things in there. First off, as I said before, an amended complaint is very standard practice in litigation. It's not uncommon for you to continue doing investigation on your own as the plaintiff and learn new facts. A lot of times in litigation, you'll see new parties that are added, maybe additional people that you find that could be responsible for whatever negligence. There's maybe a clarification. Maybe you realize, man, I let two partners review this the first time, but the third partner, when he reviewed it after it was filed, found some other things that we needed to deal with. So amending the complaint in and of itself is not unusual. Here, you had the situation where the ACC filed first, then the FSU filed. So they took all of the information that FSU filed, and that's the basis for this amended complaint. Now, let
Gotcha.
me share some new news in terms of clarifying the time frame for when this is going to be moving forward. As part of this, the AP was reporting, and one of our Knowles 247 writers confirmed that both parties filed joint filings in each courtroom saying that answers would be due on February 16th. So we will get the responsive pleadings from these parties on or before February 16th. Now, there could be a couple other things filed as well. One of the things is a motion to dismiss. Either party can ask, either defendant can ask that the other complaint be dismissed. There's a possibility that these will get remanded to federal court. One of the parties can say this belongs in federal court, not in state court. So those are the two things that I could see coming up at some point before February 16th.
Gotcha. Appreciate it.
Greg Flugar snuck in here really quick. He put in one
Sure.
question. I'll ask it because Greg is a friend of the show. He says, Doug, do you consider the ACC amended complaints as a shot across the bow of Clemson and others? I would put Miami in that same boat, who are considering to take similar action for Florida State.
100%. One of the things that are asked for in there is injunctive relief. Injunctive relief is saying to the judge, look, we don't need you to decide the ultimate issue, but we have some ground rules that we need you to help us with. And that goes to making sure that the FSU is not a participating member for voting purposes, making sure that the FSU does not disclose discovery information they provided. And I think all of those things together are efforts to discourage the other members from filing at this point. So they don't want Clemson to be stepping in and saying, oh yeah, Florida State filed and the ACC didn't do anything in response, so let's go ahead and file our suit as well. This was absolutely a defensive move on the part of the ACC to stop other members from following suit.
Could they win the lower arguments but still lose the war?
Absolutely. There's no question a judge can say, FSU, you don't get to vote at the next meeting in April. One of the things they asked about, I believe, was they were asking not to pay out some of the benefits to Florida State. I think that's a little bit more questionable. The judge would really have to feel from the initial filings that ACC's claim was slam dunk before they would do that. Because you don't want to give FSU $50 million or $20 million and then 6 weeks later hit them for $100 million in attorney's fees. So that's an opportunity for a judge to maybe tip their hand as to what they're initially thinking. But that injunctive relief is just the limited relief during the pendency of the trial.
Well, again, we're very grateful you were able to come in here. Doug Rohan, Rohan Law. And why don't you tell everybody what you do and where to find you, Doug?
Thanks. I really appreciate the opportunity to be here. I'm out of Atlanta, Georgia. Attorneys are licensed by the state. So for our national audience, I'm not here to sell you on my services. I just want to make sure that I'm a resource. But if you or any friends are in Georgia, find yourself in a position where you've been arrested or hurt on the job or hurt in a car accident, and you just want somebody to talk to about your case, maybe you have a different type of case, but you want to know if there's some good Georgia lawyers that you can use, love to have you call our office or check us out online, and we'd be happy to answer any questions you might have.
Thank you so much for coming, Doug. It's great to see you, and we'll have you back. The more news breaks, we'll be asking you again.
My pleasure. Y'all take care. Have a great night.
We'll see you later. All right, bye-bye.
Bye.